North America continues to experience a dramatic rise in dispute resolution costs. In 2024, the average value of construction disputes increased by 40% since 2021, and compared to 2019, they've tripled. Meanwhile, the time it takes to resolve these disputes has only decreased slightly. Innovations like the construction AI arbitrator can help speed up dispute resolution, but we can also rely on techniques that have been around for decades, methods designed to prevent construction disputes before they even arise.
The dominant dispute resolution culture tends to treat let's get ready for trial as the default, despite the statistical inevitability or near inevitability of there being a settlement on the proverbial courthouse steps. And, early dispute resolution through guided choice or otherwise asks a different question. It's not, only when should a dispute settle, because everyone, I think, would agree the earlier the better. But how settlement becomes achievable sooner. And it can't become achievable sooner if you get a lot of parties together that are angry with each other, that are going to talk past each other. They're going to have this premature positional negotiation. When we talk about guided choice, what we're really talking about is a form of mediation. And even though my old partner and mentor, Paul Lurie, got the phrase guided choice, really what guided choice is it's just, at least in my view, a collection of best practices that the best mediators have been using for years, even if they haven't necessarily referred to it as guided choice. It is really a way of mediating where the parties place less emphasis on the mediation being an event that happens on a certain day. Which has all sorts of negative consequences. If we just tend to think of, we're just going to show up one day and either negotiate or not, and think about more of a process. The guided choice process is something that is facilitated by the neutral, the mediator, and, there's a process where the neutral would not call for the in-person negotiating session until the parties are ready to meet. And that often involves not just an exchange of information or briefs, but confidential discussions between the mediator and the various parties to try to understand what are the real reasons that they have reached impasse, because it's generally not the things that people put in their briefs, their mediation submissions, that are really what's hanging them up. But for example, the longest dispute that I was ever involved in, and I've been an attorney for 24 years, it went on for years and years, and it wasn't because the parties didn't understand each other's positions. It's that nobody had any money to settle and there was no insurance. And so we were all talking past each other. Everybody writes their briefs about liability and damages, and everybody just sort of yells at each other, but that wasn't really what was preventing the settlement. What was preventing the settlement was that there was no obvious payor. The reasons why mediation tends to get a bad rap among those lawyers that don't like it is they've had bad experiences where mediation is treated as an event. It's going to happen on this date. No matter whether people are ready or not, we're going to come. And you get people that show up, and rather than have a fruitful discussion about what is really at stake among parties who are ready, because there's been this information exchange and people have what they need to make a business decision to settle or not, you've got people who are together in person prematurely, and you have a positional negotiation, where you've got one party saying, here's my extreme position over here on liability and damages. You got the other party saying, here's my extreme position over here. And this side is going like this, and the other side is going like this. And when you bring people together and you have a premature positional negotiation, what you have a lot of times is a failed mediation that can make things worse. It can tend to inflame passions. It can make people angry. And then you wind up defaulting into arbitration or litigation, which has its place. I've done arbitration and litigation for going on 25 years. In the last week, I have filed a lawsuit. In the last week, I have filed an arbitration. So I'm not against those tools. Guided choice uses these confidential discussions between the mediator and the parties, not just to get a superficial understanding of what the dispute is about, and then call a premature negotiating session. It's really to dive deeply into what are the causes of impasse, what's really going on here, and what sort of information exchange or what would need to take place before parties would know enough and to be ready enough to have a constructive in-person negotiation session.
Dispute prevention in construction starts with smart contract design. Key tools include equitable risk allocation provisions, assigning each risk to the party best able to manage it, incentive agreements for cooperation, encouraging collaboration rather than conflict, disputes potential index, identifying areas most likely to generate disputes, partnering programs, fostering teamwork and shared problem solving. Even well-drafted clauses aren't foolproof. Courts and arbitrators may limit or invalidate provisions if they are unfair, beyond contemplation, or against public policy. Juries may also adjust outcomes if perceived inequities exist. The construction industry recognizes 3 principles for risk allocation. Number 1, risks should go to those best able to evaluate, control, bear, and benefit from them. Number 2, every risk carries a cost, which must be assumed somewhere. And number 3, some risks and liabilities are best shared. Research shows the most cost-effective contracts assign each risk to the party best equipped to manage it and tailor risk allocation to the unique circumstances of each project.
I like to joke with the people in my office that the golden rule applies. And the golden rule is whoever has the gold makes the rules. And that tends to be the project owner, because the project owner is the one that gets to hire the architect and gets to hire the contractor. But the further you get down the chain from the owner, you find people with less and less bargaining leverage. So you take like a subcontractor, for example, that wants to be hired by the general contractor. The general contractor's got the gold, so the general contractor can make the rules. The general contractor would be in a position to say something like, you subcontractor have this outsized responsibility for safety on site, and maybe in some scenarios it would be it would tend to make the subcontractor responsible for things that they can't control, right? Because the general contractor is the one that's going to fence the site. The general contractor is the one that is going to control what happens on site. Really, the general contractor is the one that controls the means and the methods of construction. The general contractor is the one that actually has the ability to have a safe site. Whereas a subcontractor have a lot less ability to control anything other than what they do. And while it's certainly appropriate for subcontractors to have responsibility for what they do, it's harder for them to have responsibility for what others do. That tends to be something where you got to go a little bit up the chain. And so you might have a general contractor that would exact very aggressive terms from a subcontractor in terms of outsized responsibility for site safety, which, under some circumstances, I could understand the justification for doing that. But the point is that the most efficient way I have found to allocate risk is if you assume that anything that is insurable, meaning like if you can have insurance for it, that you make sure that it is insured by actual policies and smart contract language that doesn't destroy insurance. One step after that is you put risk in the lap of people that can manage it, right? Because a general contractor shouldn't want to have a winning lawsuit against a subcontractor in the event, heaven forbid, somebody gets injured on site. That's not a good outcome. You can negotiate a very aggressive contract, and you can kind of force terms on a contractor downstream that they're forced to accept because they have no bargaining power. They've got no gold. They're at the bottom of the chain. But you don't want to have a winning lawsuit against a subcontractor, for who's responsible for an injured worker. You want to not have any injured workers. And the way that happens is by having the contractor have a safe site. And it's really only the general contractor that is able to exercise that level of control over the means and methods and the safety of the site generally. So, in addition to making sure that insurable risks are covered by insurance, it's also, in my view, worth considering negotiating design and construction contracts where the risk of any particular thing is placed on whatever party is best able to manage the risk, so there can be a great outcome for all parties involved.
Whether through carefully drafted contracts, effective risk allocation, or approaches like guided choice, the goal remains the same: prevent disputes before they arise.